Buenos días, buenos días.
Good morning. We invite to take your seats. Ay, Luis.
Estou muito contente de estar aqui apresentando o primeiro painel de dia.
We are very happy to be here presenting the first panel of the day, that is the protection of intellectual property in major sporting event, the role of national offices. So now we will continue. We will show you an institutional video and appreciating once again to all the Paraguayan. This is my first time here in Paraguay. I'm very happy to be here. Thank you to the organizer committee as well. And in the name of the executive committee, I appreciate our dear Raquel from Paraguay for their hospitality. We're going to start with the institutional video.
Protección de la propiedad intelectual en megaeventos deportivos. El rol de las oficinas nacionales. Elisangela Santos, Coordinadora General de Marcas y Subdirectora de Marcas, Diseños Industriales e Indicaciones Geográficas del Instituto Nacional de Propiedad Industrial.
Claudia Franco, National Director of the National Directorate of Intellectual Property of Paraguay, DINAPI, Paraguay. Moderator, Silvina Vila, partner at Bergstein, Abogados, Uruguay. Good morning, everyone. Thank you for joining us very early in this last day of the seminar. It's a pleasure for me to moderate this panel dedicated to the role of the offices and to the organization of the major sport events, because as we all know, these sport events mobilize not only a great amount of people, fans, hinchas, as we say in Uruguay, and the industry of the entertainment, but as well includes a great number of assets, intangible assets with a high value. So, to approach this topic, it's fundamental to have the presence of our panelists that will expose about this role and this key function that the offices has in this organization and coordination of the sport events. For that, we are going to have the presence of Claudia Franco. She is the National Director of the National Directorate of Intellectual Property of Paraguay, the DINAPI. Thank you, Claudia, for joining us. And I tell you that Claudia practiced a discipline, talking about sport. I find this very interesting, and she explained to me that it's very demanding, this sport. It is sport orientation. Do you know about this? It's excellent. And we have the pleasure of having the Angela Santos. She is the General Coordinator of France and INPI, Brazil. Elisangela Santos, General Coordinator of Trademark and Deputy Director of Trademarks, Digital Science and Geographical Indications. She is a fan of Fluminense. And talking about Brazil, this country particularly have a great experience and the organization of sport events, as it was the World Cup from 2014, Olympics in Rio 2017, and next year, 2027, the female cup, World Cup, female cup. So staying in Brazil, I invite you, Elisangela, to explain to us how was the experience of INPI to try the intellectual property protection in these mega sporting events. Good morning, everyone. First of all, I would like to appreciate the hospitality of the Paraguayan people and the organization of this event and the opportunity to be in here sharing this Brazilian experience from the point of view of the intellectual property office in Brazil. We have two events that are very relevant that were the World Cup of 2014, the Olympic Games of Paralympic Games in Rio 2017, and we are organizing a new mega event that is the FIFA Women's World Cup in Brazil 2027 next year. The most important in this mega events sport that is related to the industrial property is the visibility of the intellectual property is very huge, and this visibility provides opportunities as the investment, tourism, and international for investment for the mega sporting event for all the commercial alliances, as well brings risk for attempts of inherent association. The first mega sport that we have in 2014, we have an understanding there was a need to protect this in a stronger way to diminish the risk of the inherent association, mainly to the ambush marketing. This unauthorized association, they see this, and in the first special law was born with this goal. We have a law for industrial property that provides some special protections that are very useful in a context of a mega sport event. But beside this intellectual property law, we have a specific laws in every mega sport event in 2014 and 2016, and now we have a special decree law for the 2027 FIFA World Cup. When we watch this law, we have some kind of protection that are very useful. For example, the chance that a famous brand will be acknowledged this famous trademark as official denial. No, this is a well-known trademark. So, what is important in this well-known trademark it is that we have the chance to accept the exception principle. So a brand can only will be protected in a range of activities. And these well-known trademarks presents with an exception to this principle. They request a protection for every kind of services. We believe that this is very useful for a mega sport situation. Besides the famous trademark, they have the chance to the official lines. Any opposition to reproduction or imitation or another or deceptive trademarks, they register their license in Brazil, they register and they can do this official denial if this is a deceptive trademark or they already have a third-party registered trademark, or when it's referring the name of the tournament, the cup, prices. Besides those elements that we provide with our law, this special law has the goal to bring more simplification and speed to the but only this stay. This is a special regimen until the end of a mega event year. This is very specific for the sporting mega events. Considering the simplification about the famous brands, if you have this well-known trademark, we need to have a national survey that everyone, besides the consumers, acknowledge this brand. And this brand has a good reputation. In that case, from this special law, we do not have those needs. The organizer use this law. It should be acknowledged with a well-known brand without a verification. So we simplify these procedures as well. This law brings some measure as cost reduction. This is not something easy to achieve, and as well the opportunity that the own Office of Intellectual Property from Brazil communicate directly a direct notification to the office that has their domain names on charge. So this is a measure that contributes the cost reduction. As well, we have the speed, the opportunity that our procedures have a shorter framework or time frame, and the fast track possibility in 2014, where it started with this fast track for brands, as well in 2016, but then we have a specific measure to amplify this to the trademark examination industrial designs. For 2027, we have now the opportunity for fast track for trademark examination, industrial designs, and patent utility models, not only in the priority cases, not only for the event organizers, but as well for their commercial partnerships. So we have evolved that not only focusing in the brands, we have amplified this to the trademark examination, industrial design, patent utility model for others' rights into the industrial patent property. As a summary for this stage, I could say that the offices offers, or what should offer, is a join or a gather of things that provides legal certainty, that should have tools that allows the simplification and speed, a favorable regulatory environment. This is the most important. An example or something that we have evolved is the chance to accept a slogan as a brand. That was not possible before. The last mega sport event in 2024, we change our practices, and we have a better understanding to understand a slogan that it could be used as a brand as well. Not all the slogan, but the ones that have something very original, and it could work as a brand. Other element that is very important are the tools to facilitate the defense of rights. National Directory Office for Intellectual Property, they don't do this information directly, but it could serve as a data center for information that allow us to be a connection between the right holders of the property of the brands, and as well the enforcement and the national police officers. In our office, we have a national directory for combating this counterfeiting of trademarks. So that's the composition, the essential composition, to have a balance between the rights of the right holders, the competition, the juridics legal certainty to have a loyal and just competition, as well for the consumers to not be deceived for their passion for sport. If they are going to buy something thinking that is another brand or is original. So those are our initial steps that I wanted to share with you. Thank you. Thank you very much. Elisangela, thank you for speaking in Spanish. I would like to highlight this. I have three main takeaways: simplification, speed in the processes, and legal certainty. These are the main goals of any national office. But I have a question. When we think about all of these regulations and the assets that are linked to these events, we think about brands, copyrights, and what are the relevance for the next year event to incorporate a special license for patents and industrial designs. I think that this should be added, the inclusion for the commercial partnership, because the key word is visibility for brands as well for all the industrial property rights that are involved in a very important event like patents for sport things, industrial design of, for example, the tennis ball. And we have a right gathered that may not be from the organizer, but it is for the trademarks or the commercial. We're not talking about just marketing ambush, but the risk for copy and something that is more visible that they can try to copy this and obtain benefits for something that was not invested, or they did not have any effort from the person who is trying to have advantage and commercial advantage for this. As a conclusion, what could you share from the experience about the learning that the INPI has to support these processes, coordination? What are these takeaways to highlight? I would like to mention a key points. One is about the organization, because in this mega sport event from 2017, the organization is being shared between the Minister of Sport, Minister of Development, the Office for Intellectual Property as well, the FIFA representatives. We are sure another point to highlight it is that there are some measures that should be exceptional. For example, the well-known high-level brand, the protection is. But imagine you have an amount of time that actually that this is a very specific moment of this mega sport. It should be like a takeaway or something that is not necessary. We think that the sectional measures are necessary, but there are other measures that should be permanent and other only temporal. So that balance between what it should truly be temporary and what should not be temporary, that should be permanent. For example,
another lesson was about the fast track, the recognition that there are exceptional situations that need celerity, because unfortunately we do not examine brands very quickly as they should be. So we have to make an effort to examine things as quickly as possible. But regarding that, if you don't achieve that, it's necessary to have or keep in mind there are exceptional situations, and we structure the fast track for patents is in place, but prioritizing this for brands has only been structured since last year for certain situations with justification to offer opportunities to people that request the office that their procedures be fast-tracked. For example, their paperwork be fast-tracked. For example, a situation where you're waiting for financing. If you're awaiting financing, or for example, to receive authorities, if the authorization of financing depends on the registry of the brand, for example, there are platforms for virtual markets. There's certain actions. It depends on the patent office or the copyright office. So we created a service that allows, in very specific situations, that the person requests that the paperwork be fast-tracked. So these are some lessons learned from that moment when we organized mega events, sporting mega events, that go back to a special situation where the need is great. So I think it's clear that starting from what you tell us, that the offices, or in this case, not only is it about adequate norms, but also have an office, an institutionally prepared office to confront these issues and processes. So I thank you very much, Elisangela. And now I would like to go to Claudia to give us her perspective from the DINAPI, to have a better perspective of Paraguay. Do you consider that offices should act to organize themselves and contribute to an effective protection of intellectual property, seeing these scenarios of very high visibility, large economic impact scenarios? Before anything, good morning to everyone, and once again, thank you very much for the invitation. It's a pleasure to be able to share this panel with you. Well, the offices of intellectual property in these types of events, mega events that are truly crucial, very important, not only because as organizations of intangible assets registration, we should guarantee that intangible assets, brands, drawings, industrial designs belong to the organizers of the partners, as you said, parceiros, and of the event, that they be duly protected, but also we must guarantee the correct observance of those assets. So we, from the DINAPI, have the power to carry out the observance. The intellectual property offices are fundamental in this sense. Also, it's important to keep in mind that these events carried out in our countries not only are events to make sports visible, but also, above all, they are opportunities to develop our countries. It's important that we, as offices of intellectual property, carry out the due awareness training for the businessmen, the entrepreneurs, the different industries, creative industries that exist in our country, so that this is a win-win situation for everyone, not only for the organizers, but also for the country itself. In that sense, and following that line of thought, from Paraguay's perspective, I would like to talk about the recent law of, I say recent, but it's a year old now. It's from 2025. The Paraguayan government enacted a special law for sporting events that are of international relevance. If you allow me to talk about this. Well, this law is what it intends is to attract and promote sporting mega events in our country with international standards, so we can generate a predictable ecosystem with legal security that's advantageous for both the organizers as well as the country. I was telling you our law, the 7,467 law, called the EDRI law, contemplates many aspects that, to summarize, it establishes exonerations, tax exonerations, customs exemptions. The law establishes exemptions of taxes for the importation of the temporary importation of goods, exemption of taxes on revenue and added value taxes for the organizers, for the athletes, for the technical staff, for the referees. Also, regarding migratory issues, there are exemptions and reduction of requirements, and there are free visas for certain staff members. So, regarding the event itself, the law establishes an exclusive commercial zone with a maximum perimeter of 2 kilometers around the event, and relative regulations regarding intellectual property, and specifically aimed at ambush marketing. These provisions regarding ambush marketing are part of our legislation, are applied specifically for events that are declared as that are of international relevance. We must mention that 2 of the events of international sporting relevance, the EDRI is easier to call it, just call it the EDRI law. If they are following the EDRI law, they have to be, we need a executive power, a presidential decree that establishes them as of international relevance. Regarding the articles related to ambush marketing, it permits the establishment of a perimeter of up to 2 kilometers around the event, so that along the main roadways, so that the organizing entity or their partners, your parceiros, I'm stuck with that word. You can also call them fans. Fans? Do you mean fans? Well, fans was a word that was, hinchas or fans was a word invented in Uruguay. I won't say by who, but the National Football Club coined that term. So the historical phrase is, I'll share this with Martin from Peñarol, but we have to recognize that the hinchas came from that club. So, well, so these areas or zones are exclusively for the commerce of products belonging to the organizers. The new thing is that this law, EDRI law, establishes that for cases of ambush marketing, the organizer has the right to request damages, loss of revenue, compensation for these against those who infringe on this engage against their illegal commerce. Or regarding intellectual property, it also establishes, as well as in Brazil, a system of fast-track regimen where brands belonging to the organizers and their sponsors that are included in this presidential decree that establishes the event as an EDRI event, we give them special relevance in terms of fast tracking and speed, and it also gives exclusive ownership to the organizers of all images, sounds, and expression of the events Therefore, these audiovisual rights are exclusive, and the recognition as notable brands. This is somewhat similar to how Brazil has dealt with notoriety of brands during EDRI events, with the difference, well, in Brazil they do it the same. The DINAPI will not require proof of notoriety for the brand in question. Regarding the fast-track regimen, the DINAPI has issued a special resolution 278/25 for the priority processing of brands of the organizing entities, establishing priority for the examination, the background examination, accelerated investigation, and later issuance and priority assignation of ownership. What we didn't contemplate is the time frame for that's normally 60 days. This this is a 60-day framework where other entities can oppose the decision. That is still in place. What we do, the organizers of EDRI events are issued within the 6-month framework. In addition to this fast track, the EDRI law establishes that control, monitoring, and protection of the non-authorized use of brands will be a responsibility of the DINAPI in coordination with other institutions such as the National Police, the municipality, and obviously the organizers. In Paraguay, since July of 2025, we have declared as EDRI events the FIFA Congress last year, 2025, the Pan American Junior Games, ASU 2025, the finals of the South American CONMEBOL Cup, and the World Rally Championship, a rally carried out in Paraguay, but for 2025, 2026, and 2027. And also the World Skates Games that will be carried out in October 2026. In these events, we had the opportunity as an institution to work on prevention and the withdrawal of materials that were infringing rights belonging to the brands or that were products that were working under ambush marketing. This was very important, the experience that we had in DINAPI during these events. Not only because of the emotions, that excitement that it created in all staff members because of the entire movement that we had as an institution, but also because of the interinstitutional work that we had with other national institutes that worked in a coordinated, and we have at our doorstep 2 important events, as I said, the World Skate Games and the second year of the World Rally Championship. Last year, this showed us that it is fundamental to be able to work in an articulated manner with last year's rally, since it took place in several cities on a very long road in the department of Itapúa. It was very challenging, but for this year we will triple efforts to be able to have a better coverage there was a lot of withdrawals of material that infringed on rights, and a lot of withdrawal of billboards that engage in ambush marketing, and well, as I mentioned, the interinstitutional work was fundamental. It was very important. Also, before the events, we did training, awareness, training, not only with local businessmen, but also with other institutions, accompanied, of course, by the organizers as well. And as I mentioned, we could identify several cases of counterfeit brands and ambush marketing. We could also understand that to guarantee a good protection of intangible assets belonging to the organizers and of the local businessmen, it's fundamental to do preparatory work, before, during, and even after the event. Thank you. Well, that is, in general terms, what I have, what our experience in DINAPI about implementing the EDRI law in Paraguay. Thank you very much. Claudia, I was left thinking about two things that I wanted to ask you about, because facing all of these changes and regulatory changes, how does this influence the practice? How does the awareness that you talked about of the different actors, their staff members, so how does the office prepare itself to be able to face these challenges? Because I imagine that these changes in processes, these trainings, all this work that has to be done internally is very different from what you do. It's very specific for this organization, and to be able to accompany the process of organizing the event and the development and also the post-event is important. So what does this mean for the office regarding changes? And the second question is, and you can answer it in whatever order you want, this interinstitutional work that you mentioned between different authorities, the DINAPI alongside customs and other agencies specialized in different issues. So this influences the management and protection of intellectual property. Well, the interinstitutional work is fundamental.
It's necessary the coordination among institutions. I forgot to mention that before the implementation of the regulation of this law, EDRI, we created a coordination team for these mega sport events in Paraguay that was in charge of the National Secretariat of Sport and the Olympic Committee for Paraguay. So, as we are working, basically, is in coordination among these institutions, and we have institutional roundtables before the event. Yesterday, we have one of these roundtable talking about the World Rally Championship in August, and as well, we are doing this awareness campaign trainings for local commerces in the city, the national municipality, local municipality, national police officers, and of course with the organizers and the sponsors, reporting about the due way to commercialize these products. We are doing as well workshops to identify false product, always with the support of the brands or the representative. Falsified So this coordination is in charge of the National Olympic Committee and the National Secretariat. We have meetings, not as usual, but depends on the proximity of the event. We do this previous coverage as well. So the DINAPI goes to the place or they understands the location, and after that, on the date of the event, we are early there doing the coverage to identify any kind of commercial or any sales point that can be on the infringement of their rights or the copyrights. And internally, all the actions is being carried on through the National Direction of Observance from the Promotion Division and from the fight against the piracy. As well, we have the support of other direction, and as well from the National Direction of Industrial Property, working with this every request with the speed that is required by the resolution that the fast track established. These are operational changes that we're doing internally in our direction to be able to provide the protection to the intangible assets of these organizers from this mega event. Thank you. I want to ask you a question, both of you, thinking about jurisdiction or offices in where we do not have any specific regulation or legal framework to face this kind of event. What are the practices that you consider in your experience that could be used or applied as a recommendation for this jurisdiction where there is not a specific law into this topic? Well, all legislations that are linked to the Paris Council, they have the right to protect this well-known brand. This is something that we have, and as well the chance to think in something like a fast track. And from the Paraguayan experience, I love that they mentioned training, because that was not present in our experiences. Perhaps for the wide territory of Brazil, but training is very important. This is important for the ones who use the brand without bad faith. It's important to understand that that is a practice of ambush marketing. So I think, and I truly like that point about doing the training courses, the training from this interinstitutional training for the informants of the right, even though they do not have a specific law, because for exceptional measure, perhaps there are limits in the legal framework, but that kind of practices, that type of articulation is possible, even though we do not have something special as a specific legislation. Yes, I agree with Elisangela. The training through this, I think this is a fundamental strategy when we do not have available specific laws. From the experience that we have, is truly take our attention the salesmen that are on the street or the handcrafter that prepared their scarf with the color of the selection, and they didn't know that they were actually doing a rights violation. And from our experience, we have a good a good interest from this Chamber of Commerce. We have the chance to trade them, and I think this is fundamental. And as well, the enforcements, the brand, the protection that the notary brand provides in case that we do not have this kind of legislation to protect the copyright. So if you have a question from the public, you can request the microphone. And now we're going to open space for questions. And taking advantage that we have the two authorities here on the stage, please take this opportunity. Thank you, Silvina. Congratulations for three of you. Something that Claudia mentioned at the end. We have this well-known trademark, and the last day we see Elisangela, that there was a modification in the law of Brazil about the request for the well-known trademarks or recognized trademark. Now you can present a file for this for different types, but it was not clear for us how this is working. Please, could you explain to us? Well, the well-known trademark started from 1996 in our law in Brazil. When this law was issued, the well-known trademark or recognized trademark can prove that they are recognized through the population, and as well they have a great reputation to the point that there is a similar brand. The population may require, or the population may be deceived, and there is a procedure to prove this. We need a survey, a market survey, that proves that the greater part of the population acknowledge this brand that is well known, that they have a great reputation. And in this case of mega sport events, we have a section that is not necessary to prove this, but the organizers can present into the to the office a group of marks that they consider that there's slogan or the brands that are from their trademark. We will consider this as a well-known trademark till the end of the event. That's something temporary, that's not like other cases. So the brand that is acknowledged as a recognized trademark has a protection of 10 years. This Coca-Cola, for example, is a recognized trademark in our country, and as well a football club that is well known is Flamengo, but Fluminense does not have this recognition. But for this, we need to prove this through a market survey with a diversified group of people from the country that, besides being well known as well, they are recognized and have a great reputation.
Protecting the name, this is for all classes of products and services. That is in the law. If the brand is recognized, or it can stop other products and services. That is the point. That was what makes it different from the well-known trademark, Elisangela. It's very good that we have 4 cups in the Libertadores, so all Brazil knows it. So on the other hand, I represent Coca-Cola. I've been representing Coca-Cola in Brazil for many years. We have obtained recognized trademark. That's very clear. And the question is, the executive committee had understood that there was a modification. For example, I'll give you the Coca-Cola example. Coca-Cola has has registered the Coca-Cola name, a visual logo, and can they bring different classes together, or bring all the classes of registries together and ask for a single new one? Is that in the new rules? So the question is that specifically. So there can be other registries of brands from different types of. There can be mixed types or different types, and bring them all together and establish them as a well-known trademark. Or do we have to ask them separately? Or I understand now. We had a change, but I'll try to explain. To request recognized trademark, it's necessary to be registered. You can't request more than one type of brand, a name brand or a mixed brand, image and name. So, but this is based on one registry. For example, the name of Coca-Cola. You request this as being a well-known trademark. Then recently we changed the rules for well-known trademark to accept that you can request this based on more than one registry. For example, that's a benefit, a special benefit for some trending sectors. For example, brand can be well known among the population, but maybe clothes, maybe others could be bags. So if products are in different classes, there is the opportunity to request well-known trademark for many types of products, but the name has to be the same. The name has to be the same, even though you have 3 or 4 different types of products. You can still ask for that registry or well-known trademark. That is important because of the market survey. In the market survey, it must be clear that people know the brand or trademark as it is registered in the office for the products and services that are protected by that registry. I don't know if that makes it any clearer, but in protecting, we always request. So we need at least one trademark or brand registered to have this. It depends on the type of brand. Was that clear now? Yes. Okay. Does anyone else want to make a question? Thank you, Elisangela. Thank you, Claudia. I have a question for Elisangela. Elisangela, you mentioned this system, special system, the fast track for the Women's World Cup. I would like to know if for well-known trademarks as well as normal, regular brands, I would like to know if you're thinking about some type of monitoring prior monitoring regarding third-party brands. I ask that because Brazil follows the force to file system. I don't know if a third party requests a brand or a trademark, for example, that FIFA will use. For example, for the Women's World Cup, how are you doing follow-up on this? Do you have a way that prevents this, especially based on third-party trademarks that will belong to FIFA or any other company that is related to FIFA? Do you have that or not? We don't have any monitoring on behalf of the office. The monitoring must be done by the organizers themselves. We don't have any specific monitoring. The organizers should present all of their requests that have to go through the fast track, but the office will not monitor ex officio. No. During the examination, if there is a prior brand of FIFA, then it will be denied. But we won't monitor the third parties. That monitoring should be done by the organizers. Anyone else? Would anyone else like to ask a question? Thank you. For Claudia, I wanted to ask you, you mentioned that the EDRI law has a mechanism to request compensation for damages in cases of ambush marketing. So the question is, what mechanisms does that law establish to determine the compensation amounts if there is ambush marketing, if there have been any cases already, and if the concept of this, if this damages has any practical application in reality, or is it just on paper? Is it just in a legal theory that exists? Well, thank you very much for your question. No, the law, EDRI law does not contemplate the mechanism of compensation, but obviously the way in which we can be compensated or get compensation indemnization is through civil action. I have no knowledge that there have been any cases in the past. However, I imagine that there could be in the future, in the next coming years, depending obviously on the quantity of the damage, the amount of damage. But there haven't been, in what already happened in the past, in the EDRIs that we, the prior declared EDRIs, at least in the DINAPI, we had no awareness that any type of legal action was carried out regarding compensation for damages. Anyone else? I have one last question as well, but I was reserving this for the end just to give the public room for questioning. Okay, so if there are no questions regarding training and best practices that come from these exceptional situations, special situations, but that could perhaps be evidenced or be incorporated into a general practice in the office, starting from these experiences that you could consider. What do you consider about this? What do you think about it, Claudia? Well, we in DINAPI, we have constant ongoing training in the direction of promotion. We have training not only to the general audience, the public, but also for the police forces, the public ministry. It's one of our missions in DINAPI. We constantly carry forward awareness campaigns and training campaigns, but not only in sporting events. You have also have extended this to everything related to intellectual property. We have training for entrepreneurs, for specific creative industries. We have visits from universities that come to DINAPI, where we give them a tour through DINAPI and explaining to them what each office does in DINAPI. So we create awareness and train on intellectual property issues. That is something constant that we do. It's constant. It's one of the tasks that are essential and key for any national office. So, Elisangela, to end in these few minutes that we have left, in Brazil, we have some types of cooperation with university and other institutions that allow us to reach the population more closely. But we still have the challenge, because we are a very large country with continental dimensions. So there's also difficulty in explaining the technical language. It's very technical. It's very difficult to reach the population, reach the common person that many times do not understand the importance, the relevance of intellectual property. So that's essential. It's fundamental that all offices have or try to overcome that obstacle, overcome that challenge, and reach the common man, the people that are in our population. We are trying to do so. There are several efforts, and perhaps we will manage to have that in the future. And hopefully it will not be limited to these events. That it could be an institutional practice in the future. So we thank you once again to both of you. And to conclude, we could point out that since we are approaching a mega event, this must be planned ahead of time, and the special arrangements like you just presented, they have the objective to bring more celerity, more speed, more legal certainty in the processes, and the role of the national offices, without a doubt, is strategic in these cases to bring predictability and trust. Thank you for being with us this morning, and it's a pleasure to speak with you. Thank you very much.